My name is Jon Mowbray. I'm a partner in the Real Estate Dispute Resolution team at IBB. Well, most such properties will be held under a lease. If we're instructed to act for a client on the grant of a new lease or the renewal of an existing lease, we will look to agree the form of lease so as to limit the risk to the client, whether that be in relation to their ability to exercise a break option in the lease, the ability to dispose of the property if it becomes surplus to requirements, limiting service charges, and in relation to their repairing obligations, both during and at the expiry of the lease. However, it's not possible to exclude all potential of a dispute. And for example, a client may well have acquired a lease, say as a result of a corporate transaction, whose terms are far from ideal. Well, I think generally we're seeing landlords looking to get as much out of their properties as possible, and against this, tenants are under real pressure to reduce their occupational costs. Now, this undoubtedly creates a tension. In particular, we're seeing this manifest itself at the end of a lease in relation to a tenant's repairing obligations, a dilapidations dispute. Now, while there is a court protocol which deals with how such disputes should be dealt with prior to court proceedings being issued, and while that protocol encourages landlords to really focus on what their true loss is, we are still seeing a number of what appear to be very inflated claims. Ideally, we would look to work closely with the client's other advisors, building surveyor, valuer, to come up with an overall strategy to challenge the claim. Now, this will include reviewing what the client's actual obligations are, both by considering the terms of the lease and its surrounding circumstances, considering whether certain works the landlord is proposing go beyond the tenant's obligation, considering what the landlord's actual intentions are with the property. For example, does he intend to carry out substantial refurbishment works, which would render many of the repair works superfluous? And also a consideration of what the hypothetical purchaser will consider was the value for the property in and out of repair. There certainly can be an overlap. A landlord may be maintaining that the cladding needs to be replaced in its entirety, for example, or that a new roof needs to be put on. But it may be the case that these works go beyond what is actually required under the terms of the lease. Matters can become particularly contentious when a landlord is looking to put major works through the service charge towards the end of the term. Understandably, a tenant will be reluctant to fund these given that it will get little or no benefit, and it may be possible to argue that such works are unreasonable. It would also be important to look at whether the landlord has strictly complied with the service charge machinery, as if he has not, one may be able to argue that any sums demanded are not yet due. Regrettably, yes, landlords undoubtedly were keen to keep tenants locked into their leases, and therefore they would look to take advantage of any failure to properly comply with the service requirements for the notice, the form of the notice, and any conditions which need to be satisfied in order to effectively exercise it. Now, while we're generally seeing in leases there being less conditionality, perhaps just limited to having to pay the rents due under the lease and provide vacant possession on the break date, even these conditions can present traps for the unwary. And that's why the tenant client needs to get properly advised about how it can effectively exercise the break option. If you would like to discuss any of these issues or related matters, please contact me, Jon Mowbray, at IBB Solicitors.